And here, we have also established the legal causation. So the causation part is done, all right, for this particular one. You might argue it differently, but that doesn't matter. Because at the end of the day, it is how you present it with your evidence, how you put forward your argument, okay? But this is just for illustration. I'll tend to argue it. Okay, Gabriel, you asked, is it appropriate to say R and Jordan is confined to his own facts? Generally, we will apply R and Smith. Of course, everything is confined to their own facts. That's why at court, we always say, as a defense counsel, I always try to distinguish a particular case, because I would say this, for this current case, the facts are different, okay? That's why I say there's no right or wrong answer. R and Smith, I would say, would be the traditional argument, okay? I would say most of the time, if there's nothing unusual, unless you have palpably wrong, then R and Smith would be the mainstream case that you would use, okay? Only if you are given some sort of additional information, okay, where you may suspect that there could be palpably wrong, the existence of palpably wrong, then you would say R and Jordan. Okay, Gabriel, is that all right? All right, good, Gabriel. Any questions from the floor? Anyone? No one? Okay, let me move on. Yo Yin, you have something. You can type. I'll answer that. Okay. Let me see for the next slide. All right. Will we apply the cases from tort in legal causation? Good question. Okay. I'm going to cover that next. So have a little bit of patience. Okay. What legal causation, tortious act, whether that will apply in a criminal case. Okay. We will come to that one. All right. Now let's go to crime scene number 3, Eddie's death. Crime scene number 3. Remember the facts of the case, okay? George argued with Eddie, and then there was some sort of chasing after Eddie. Eddie fell, and then George stamped onto Eddie's head, and Eddie died. Okay, so basically that's a nutshell. And here are the crucial facts. I hope you can pick that up too. Now, whilst on bail, remember it's on bail, George visited his local pub, and then he had an argument with Eddie because they were talking about some sort of Greek poetry, okay? And Eddie insulted George because of his low IQ. And Eddie, in the argument, was very angry. So Eddie rushed over to George, threatened to kill George. Thereafter, Eddie ran out of the pub to escape. And George hotly pursued Eddie. So basically, there's no time in the middle. Eddie just ran out to pursue. George just ran out to pursue Eddie. And outside the pub, Eddie tripped and fell onto the pavement. And whilst on the floor, George stamped onto Eddie's head, and Eddie died at the scene. Now, when we have the postmortem, we found out more. We found out that the actual cause of death was due to a heart attack. And the heart attack was caused by a thyroid condition that not even Eddie himself knew about that before. Okay, see, a lot of additional information that are being put in. Some can be red herring, some are crucial facts. You need to address them. All right, so let us move on to the next one. Again, remember, homicide cases, factual causation must be established. Legal causation must be established. If causation cannot be established for either one of them, it is not a result crime. That's the end of the story. Prosecution has no case against the defendant. So let us look at the factual causation first. Factual causation, we can close our eyes. 1990, out and white. But-for test. What about multiple but-for? Multiple but-for does not matter as long as the Defendants Act is just one of the causes will suffice. Okay, it does not have to be the key one. As long as this is one of them will suffice. And in our case, and when Eddie was lying on the floor, we had George stamping on Eddie's head, and Eddie died at the scene. Would you say factual causation can be established here? Can anyone tell me whether you think factual causation can be established here? Anyone wants to volunteer? I would argue that factual causation is established here, okay? Because it's a straightforward stamping on the head, one of the multiple but-for causes. As long as one of them, that would suffice. Factual causation established, okay? All right, let us move on to the legal causation. Legal causation, again, remember, we have to look at whether defendant's act is a significant and operating cause of the victim's death. Au and Cheshire 1991, okay? Significant means more than, minimal, more than trivial. Operating cause means no NAI. If it is no NAI, that means it will not break the COC, okay? Have that framework in your mind. And let us look at them and applying the law to the facts of the case. Now, do you think stamping on Eddie's head by George is a significant cause? I would argue that's the case. I would argue it is a significant cause. Are there any NAI that would break the COC? Let us look at that. All right. Now, George chased after Eddie. Eddie ran out of the pub. Eddie tripped, and then he fell on the ground. We asked the question, did the defendant put the victim into a stressful position here? Would you agree that the defendant, George, actually put Eddie into a stressful position here? Yes, Choi San, thank you very much. Okay, now, you also have to look at the case Au and Williams, 1992. Au and Williams said that the victim is not expected to act particularly sensibly, provided that the victim's action was not daft. If the victim's action was not daft, the COC would not be broken. So let us say Eddie had an argument with George, and then George chased after Eddie, then Eddie was running away. Would you think that is a daft action? Would anyone think of that as a daft action? I would say no. It's just a natural response. You had to run away because you're being chased, okay, in that respect. So if it is not a daft action, COC would not be broken because there's no NAI here. All right? You would use Au and Williams to say it is not a daft action. Okay. Any question on this one? No. And then you also have to ask another question. We've been told that the actual cause of death was a heart attack due to an existing fibroid condition that not even Eddie was aware of it. Is that pre-existing condition an NAI that would break the COC? We have to look at Au and Hayward, the eggshell skull rule. Can anybody recall the eggshell skull rule principle? Can anyone recall here? Very important, okay? Eggshell skull rule is applied every day at court. Take the victim as he is, very good, Yok In. Take victim as you find him or her, Gabriel, very good. That means if you have someone that you punch that person, the person just stand there, not even having a bruise, okay? That's very strong victim. However, you also have to take into account that someone, you punch that person, the person will die at the spot with the same strength because the person is susceptible to any sort of strength, okay? Or could have the person might bleed, the person might not have the capability hear me again? I'm sorry for the disruption because there is a breakdown in the network here. Can anyone hear me? Could anybody hear my voice? Thank you very much, Gabriel. I'm so sorry to the whole class. It is always the case when I start my webcam and when I talk and when I start sharing, this is what happened. So why not? Maybe I'll just pause the webcam. I'll continue, and later on I'll switch on the webcam. I'll see you again. Okay. I don't want to give you disruption. All right. Now, let us look at that. Legal causation established, factual causation established. Okay, let's move on. Okay, remember for crime number 1, which is the death of Ethel, George and Mildred would be charged with manslaughter. Okay, prosecution is going to charge them for manslaughter. And let us look at one possible offense of manslaughter. Remember, manslaughter has 2 types. One is voluntary manslaughter, and the other is involuntary manslaughter. And voluntary manslaughter has the mens rea, whereas involuntary manslaughter does not have the mens rea. Okay, and let us look at this. First of all, let us try to look at the possible offense of involuntary manslaughter under the GNM, gross negligent manslaughter. Okay, now if we look at that gross negligent manslaughter, the case to establish must be the Au and Adomaco, 1995. And for GNM, there are 4 limbs. 4 limbs must be established in order to arrive at a GNM offense. Okay, limb number 1 is you ask, did the defendant must owe the victim a duty of care here? Okay, and the general principle. Remember, I remember earlier on, Yuk Yin. I remember Yuk Yin. You asked me about applying tort in legal, in criminal law for negligence. Okay, it applies. We follow the law, the torts law, and that is because of the case by Au and Wecker. Okay, that is the case of Au and Wecker. It's a case of 2003. And Au and Wecker in here, it discussed what we call the extirpi causa non oritur axial, which is about the duty of care in a criminal enterprise. If anybody can remember this particular case, this is a very sad case, whereas it was the death of 58 Chinese immigrants at the Dover port in the UK. Because they were being shipped over as illegal immigrants, they were being put in a container, and all of them died. 58 of them died. So before, the principle of extirpi causa did not operate in criminal law. That means the duty of care of tort did not apply in the criminal law. However, because of this Au and Wecker 2003, they changed. They apply the torts negligence, civil negligence duty even to criminal enterprise cases. Okay, and in that particular case, Au and Wecker, that driver was eventually found guilty of manslaughter, and he was sentenced to 14 years in jail. This particular case is very important because Au and Wecker basically changed the previous understanding of what we call the principle of extirpi causa. In the past, criminal law does not operate to negate a duty of care. However, after this case, criminal law also takes into account of the tortious negligence duty. Okay, so basically you apply torts duty of care for negligence. All right, and here, moving on, Au and Stone and Dobinson 1997, and where the defendant, okay, I'll try to switch on again, and where the defendant assumed responsibility for the victim, the defendant has a positive duty to act in a certain way. Otherwise, it will become a culpable failure to act. That means it is an offense. Okay, Au and Stone and Dobinson, 1997. Applying our law to the facts of the case. Did the defendant, George and Mildred, assume the responsibility to take care of Ethel? The answer is yes. Is there a duty of care there? Can that be established? I would tend to argue yes. Okay? Because we apply the tortious law of the duty of care, just like the negligence in tort. We apply that because of the case of Au and Wecker 2003. Okay? Hopefully, I have answered your question about Yok-in. Hopefully, I've answered your question about whether we will apply the cases from tort in legal causation. Okay. Now, and good. Let us move on to the next one. This is NIM number 1. We still have 3 more to go because there are altogether 4 in Au and Adomoko. You must remember, Au and Adomoko, there are 4 limbs. Number 1 is D must owe we a duty of care. Number 2 is, did the defendant breach that duty of care? You have to look at Blythe and Birmingham Waterworks, 1856. What does the case tell us about the legal principle? D must do something that a reasonable person would not have done, or fail to do something that a reasonable person would have done. Okay, very simple. Reasonable person would not have done. D must have done something that a reasonable person would not have done, or fail to do something that a reasonable person would have done. If it falls into it, then there would be a breach of duty of care. Now, did the defendant exercise the proper duty of care, proper degree of care? I would argue no. They just left them. They just left Ethel in the room for 3 weeks. Basically, Ethel was actually in pain. Now, and what could the defendants have done at least? The defendant could have called a social worker. The defendant could have called the police for help. The defendant could have called for the ambulance even earlier. So these are something that you might want to argue to establish your argument for limb 2. And with that argument, I would tend to argue that the breach of the duty of care was established. Okay, you might argue it differently. There's no right or wrong answer, but this is just an illustration. Okay, as long as you have the relevant law being applied to the facts of the case, you argue it, you can get equally good marks. Okay. No question? Any question for this one? All right, okay. Limb number 3, the defendant must have grossly breached his duty of care. Now, the word which is very important is grossly. Okay, we look at Au and Adomoko again. Au and Adomoko says it must fall well below the reasonable man standard. It must be well below. And also talking about the reasonable man standard. Au and Bateman, 1925, said it must show a serious disregard for the life and safety of others. Okay, and 1999 AG reference number 2, Attorney General reference number 2, it says the defendant needs not foresee death or serious bodily harm. But a reasonable person must have been able to foresee a serious risk of death. So again, we apply the reasonable person's test. Okay, whether a reasonable person must have been able to foresee a serious risk of death here. AG reference number 2, 1999. So let us look at that. For our case, there was a neglect of 3 weeks. We remember 3 weeks. They only fed Ethel with food, and they were just too panicking. They did not want to go in because of the crying of Ethel, and that's it. Ethel was in deep pain. Okay. Did the defendant meet any or all of the above? First of all, the neglect, okay, definitely must have fallen below the reasonable man standard, because a reasonable man would have called for help. It must show a serious disregard for life and safety of others. So I would agree, yes, Au and Bateman fulfilled. And we are not asking the defendant to foresee death or serious bodily harm, but we are asking just a reasonable person. Okay, reasonable person. If the reasonable person can foresee a serious risk of death, that would suffice. So imagine you leave someone neglected for 3 weeks in pain. A reasonable person must have been able to foresee a serious risk of death. I would argue that's the case. So did the defendant grossly breach the duty of care? I would tend to argue yes here. All right? So we move on with that. I would tend to argue it's yes. Yukin, you have question? All right. And if I move on to the next one, limb number 4, remember we have 4 limbs. The breach of the duty of care must cause the victim's death. The case for that is Dalloway, 1908. This is confirmed in Dalloway. And in our case, remember, legal causation, factual causation, from day one we have already established. So causation has already been established. And in the exam you say causation was established. See earlier, because you have already done that. We have done the causation exercise first. And with all this analysis, with all the 4 limbs, we will tend to argue that if it is manslaughter, it could possibly be gross negligent manslaughter, which is an involuntary manslaughter. All right. So this is one way of arguing it. Any question on this? Now, moving on to crime number 2. Crime number 2. Here, remember, it is only about George. Don't talk about Mildred, because it's nothing to do about Mildred. And if you put down Mildred, you'll be penalized for your marks, okay? Because you are only asked to talk about George, since George is the only one here. George was on bail. There was an argument with Eddie. There was a chase after, and then there was a threatening of death. George chased after Eddie. Eddie tripped onto the floor. George stamped onto the head of Eddie, and then Eddie died. Okay? Now, it is likely that the prosecution will go for murder. Okay? However, we have to look at that in 2 different scenarios. Let's say for murder. Okay? Murder, the case is Cunningham, leading case, 1982. Murder is the unlawful killing of a person in being in the Queen's Peace with malice aforethought. All right? Very important to remember. It's malice aforethought, not afterthought, not whatever thought, because in exam, whenever I mark the paper, I see many different versions. It is always malice aforethought, A-F-O-R-E-T-H-O-U-G-H-T, okay? Get that right. Somehow, every year, I see people putting down different words, and you get marks deducted. You don't want to make that silly mistake, okay? Because it's malice aforethought. What is malice aforethought? You have to look at Cunningham 1982 or Maloney 1985. What it says is whether there's an intention to kill or cause grievous bodily harm. All right? And intention you want to discuss further, because you want to establish whether there is intention. Intention can be either direct intention or oblique intention. Maloney is the leading case that talks about direct intention. Maloney 1985 is the lead case for direct intention. And the question to ask is the defendant's aim or purpose to cause death or grievous bodily harm? Okay, if it is, then direct intention is established. If not, then prosecution may go for oblique intention, or the jury may go for oblique intention. Okay, oblique intention, the case to look at that is Au and Woolen, 1999. 1999, Au and Woolen. And basically it says, if death or grievous bodily harm is a virtually certain consequences of the defendant's act, and the defendants realized that it was virtually certain from his actions. So you can hear, there are 2 things here. One is, death and GBH is a virtual certain consequence of the defendant's act. Number 2 is, defendant realized that it was virtually certain from his action. So you can see that these are very fact sensitive, and this is how you can argue which way you think your argument, the facts are driving you to come to your conclusion. Okay, very fact sensitive. Prosecutor, most likely they are going to to put forward on murder. Okay, they would tend to argue that basically it's a direct intention that's causing death because it's stamping onto someone's head, and even if there's no direct intention, prosecution would say defendant must have realized that by stamping onto someone, that it's virtually certain that someone would die. However, you as the defense might argue it differently. You might want to argue it, okay, stamping on the head of Eddie by George, was that malicious, or was that what we call innocuous, meaning that it's not malicious, okay? And you want to put forward your argument to say, did the defendant have the intention to kill or cause grievous bodily harm? Was direct or oblique intention there or not? I will leave it to you to elaborate, okay? Here, I would, for murder route, you will have to establish all the intention, okay? If it's not direct intention, you have to establish the oblique intention to establish murder, all right? Now, however, if that cannot be established, then another alternative is, as a defense counsel, because you can advise your parties, would be on let's say manslaughter. Okay, manslaughter. Remember, we have voluntary manslaughter, we have involuntary manslaughter, and if we go for, let's say, if we look at partial defense, loss of control here, loss of control here is the voluntary manslaughter path with the mens rea. Remember, voluntary manslaughter has mens rea. IVM does not have the mens rea, and voluntary manslaughter is either diminished responsibility or is the loss of control. Okay. Now, I want to ask all of you, okay, on the floor, loss of control, okay, any particular significant for that one, okay? Anything, or let me put it in another way. Let me put it in a different way. Remember, I earlier I mentioned about that prosecution always have to bear the burden of proof. Okay, in what we call in the case of voluntary manslaughter. Okay, can any one of you let me know which one reverses the burden of proof? Can anybody remember which one reverses the burden of proof? Meaning that it's the defendant who has to adduce, who has to bear the, okay? For voluntary manslaughter, which one reverses the burden of proof? Can anybody remember? No. Very good, Gabriel. It is diminished responsibility. I asked you this question is because every year people got it mixed up. Okay, some students say loss of control would diminish your responsibility and would actually reverse the burden of proof. No, that's not right. There are only two scenarios that would reverse the burden of proof. One is diminished responsibility, as Gabriel said. Number two, can anybody remember what that is? Apart from diminished responsibility, there's another thing where it reverses the burden of proof. Okay, that is not within the manslaughter. That would be like that would be insanity. Okay, for insanity, the burden of proof reverses back to the defendant. Okay, but for voluntary manslaughter, remember, definitely, please remember, it is diminished responsibility that would reverse the burden of proof. In all other cases, the prosecution always bear the burden of proof. Okay, don't get that wrong. I hope you don't get that wrong, because every year when I mark the paper, I see people get that wrong. That is a fundamental error. Okay. Thank you, Gabriel. You have pointed it out. Diminished responsibility reverses the burden of proof, not loss of control. Okay. Okay. Let's start with the loss of control, partial defense. And voluntary manslaughter here, all right, is under loss of control, is under the section 54 of the CJA, Coroners and Justice Act 2009. And here, remember, it's three-limb test. Very important to remember, it has three limbs. And under section 54 to 55, basically, it abolished limb number 1. Okay. And also, if you look at section 54.2, now you don't really have to establish a sudden loss of control anymore. And section 54.4 also said that any defense would be excluded if what the defendant did was considered to be a considered desire for revenge. That means a planned desire to revenge. Okay. And what does considered desire for revenge means? To exclude your defense, what does it mean? You have to look at Al and Evans 2012. It says that you have to give it its ordinary meaning in English. It requires no further explanation by the judges to jury. So you just attach the ordinary meaning in English understanding, okay? So in our case, there was an argument, there was the insulting comments from Eddie to George, and also there was the death threat, and Eddie was being chased after. George went out when Eddie tripped over. George stamped on Eddie's head. Eddie died. I would say that there was no cooling off period, and there was no considered desire for revenge. There was no plan, premeditated, considered desire for revenge here. It is more like what we call a hot-blooded killing here. So I would tend to argue that limb 1 is satisfied, because it would have fulfilled all the limb 1 elements. Okay? And if we move to limb 2 is about section 54.1b, loss of self-control resulting from a qualifying trigger. So what is a qualifying trigger? Qualifying trigger is defined as either one of section 55.3, 4, or 5 for loss of self-control attributable to A, the defendant's fear of serious violence from B against D or another identified person, or B, a thing or things done or said or both which constituted certain circumstances of an extremely grave character and caused D to have a justifiable sense of being sensitive, okay? So is limb number 2 satisfied? Depending how you argue. I would say that it is not in my submission here, which is not the full answer, okay? I'm trying to argue that limb 2 is not satisfied. All right, you might have a different argument. It's fact sensitive, okay? Now, number 3, section 54.1c, it says, a person of the defendant's age and sex with a normal degree of tolerance and self-control in the circumstances of D might have reacted in the same or in a similar way to D. Very important to note that section 55.3 reference to the circumstances of D is a reference to all of the defendant's circumstances other than those whose only relevance to the defendant's conduct is that they bear on the defendant's general capacity of tolerance and self-control. So it's always looking at the normal degree of tolerance, okay? And its circumstances other than those, remember. So in our case, George has lower IQ than other people, lower standard of, would he have a lower standard of self-control, a relevant consideration? I would tend to argue that according to the law, no, because we are looking at normal degree of tolerance. So here, limb number 3, I would argue, is not satisfied. So we have established out of these 3 limbs that limb number 1 is okay, limb number 2, depending on your argument, but, and limb number 3, no. So 2 of the limbs would not have been satisfied for the partial defense of the loss of control. All right. Another alternative route that you can consider is the UAM, the involuntary manslaughter, okay, which does not have the mens rea element there. And there, it is in the case of AG reference number 3, 1994, the leading case, where Lord Hope, the House of Lords, laid down 4 limbs tests. Let us go through that together. Limb number 1, you ask the question whether the act was done intentionally. Okay? In our case, George was stamping on Eddie's head. Was it intentional and voluntary, that is with a conscious mind? If that is, limb number 1 was satisfied. I would tend to argue from the facts of the case that that is. Okay? That is satisfied. And limb number 2, you ask yourself the question whether the act was unlawful or not. So what is an unlawful act, you might ask? You have to go into the case law of Franklin 1883. Franklin basically says that if it is tortious or contractual claims, they will not suffice as an unlawful act. So just civil claims are not unlawful acts as such. And Lamb 1967 says all elements of the unlawful act must be present. If you miss out any one of the elements, that would not be fulfilled. Limb number 2. Okay. Now, in our case, in George stamping on Eddie's head, there is an intentional or reckless application of unlawful force. Can anybody find an act in criminal law where we can use that to base upon for this limb number 2? Can anybody on the floor think of a crime that we can use as the basis for this unlawful act? Anyone? Very simple, this is. Okay? It is battery, remember? Battery is defined as the intentional or reckless application of unlawful force. So here we have this base crime established. And limb number 2 is established. Okay, so far, out of the 4 limbs, we have limb number 1 with limb number 2 established. Let us move on to limb number 3. Limb number 3, you ask the question, as Lord Hope in the case has required, you ask whether the act was dangerous because it was likely to cause harm to somebody. So you ask the question, what is the test for dangerousness? That would be in Church, 1966, leading case. And the test is, all sober or reasonable people would foresee the risk of some non-serious harm as inevitable as a result of the unlawful act. Okay? And in Ball, 1989, F in 2015, any characteristic that makes D less able to foresee the consequences of his actions are irrelevant. Okay? because George has a low IQ, that would be irrelevant. All right. Reasonable and under M 2012, reasonable and sober people would not have to foresee the risk of the precise type of harm sustained by V, the victim. The reasonable and sober people will only need to foresee some non-serious harm. So the threshold is very low. Okay, some non-serious harm. And applying the law to the facts of the case. Applying Church, all sober and reasonable people would foresee the risk of some non-serious harm. So stamping on the head by George on Eddie, all sober and reasonable person would foresee some sort of harm. Yes, that would be fulfilled. Ball and F, any characteristic that makes D less able to foresee the consequences of his action are irrelevant. So we use a normal person's tolerance level. We look at a normal person's capability. And for these George low IQ, that is not relevant. Okay. And also M, let us look at that. Reasonable and sober people would not have to foresee the precise type of harm sustained by V. It's a very low threshold. You just need to foresee some non-serious harm. So stamping on the head, of course, there will be some harm. Okay, that would be fulfilled. So in actual fact, limb number 3 is also fulfilled. I would tend to argue. All right. And let's go to limb number 4. Now, limb number 4, you ask yourself whether the unlawful dangerous act actually caused the death. That is the easiest part, because remember at the very beginning, we did the causation exercise already. So you can see how neatly that is. Once you have done the causation exercise for all the crimes, if you cannot establish legal and factual causation, there is no resulting crime. That will be the end of the case. There's no case to answer. But if you have the legal and factual causation established, then you will have the case to answer. And here, limb number 4, you can say causation established, see earlier. Neat and tidy, then you can move on. And because of the fact that limb number 1, 2, 3, and 4, all 4 limbs have been satisfied, it is quite likely that George would get the unlawful act manslaughter charge attached to him. And remember, UAM is 18 years. Okay, UAM is 18 years as a start point. All right, and GNM, gross negligent manslaughter earlier, is 12 years, and as well as the loss of control is 14 years. Okay. So conclusion, let us wrap that up. For crime number 1 against both the defendants, George and Mildred, about Evel's death, it is going to be likely to be IVM, gross negligent manslaughter. For the case of George stamping onto Eddie's head that led to Eddie's death, prosecution might press for murder. However, if your argument can lead you to a loss of self-control, okay, it will be voluntary manslaughter. And if that is not established with the 4 limbs that we've just covered, it is very likely that George will be landed with the involuntary manslaughter of the unlawful act manslaughter. Okay, so you have the beginning of the paragraph talking about how you're going to cover your analysis. You're going to do a causation analysis at the very beginning, and then you come to the discussion of the possible offenses. And when you come to a conclusion, you put down these are your suggested proposal. Okay, so that's it. Remember one thing, you can understand that what we have talked about tonight can be handled quite systematically as long as you have a framework in mind, as long as you know about all the case law, as long as you highlight all the key facts, as long as you can apply the facts of the apply the law to the facts of the case and argue through logically. A lot of them are very, very fact sensitive. So you might have a very different answer from the person next to you. But you must be able to adduce your evidence in a way to make the examiner or the marker to convince them that you have applied the law to the facts of the case and logically argue it through to come to your conclusion. There's no right or wrong answer. But murder cases are difficult. If you can put in more time to your preparation, that's achievable. Because as you can see, we have gone through how to do causation. We have gone through about murder. We have gone through about manslaughter. We know about voluntary and involuntary manslaughter. And in the case of voluntary manslaughter, we know about diminished responsibility, loss of control. And if it is the loss of control you want to argue, you must know the three-limb test. Okay, basically Section 54 of the Coroner's and Justice Act. When you go to the involuntary manslaughter, you must have in your mind the UAM, GNM, as well as the reckless manslaughter. And tonight we have gone through the UAM and GNM, okay? And the UAM is the four-limb test, AG reference number 3, 1994, where we've just covered Lord Hope, House of Lords. And for the GNM, you will have to look at the four-limb test, Au and Adomoko, 1995. If you can get that in your preparation notes, if you can do a systematic analysis of that, you're home and dry. Okay? So I hope all of you can get something out of this evening tutorial. It's very, very substantive tutorial, and you will appreciate that the reason why I asked you to read in advance, to read the question in advance, to get some of the bullet points ready before you come to the class. And when we get to the next tutorial, it's even more speedy, because there are a lot of things, a lot of concepts about the equity and trust that are being discussed there. Okay, and I would also pinpoint areas where I think you can get more marks if you put forward that in your exams. Okay, that would be left to the next tutorial. But I would wish that all of you can put in the efforts to read the question, attempt it. You don't have to write a long answer to it. Just attempt it with bullet points, put down the key cases, and then we can discuss together. Okay? Reckless manslaughter, I'm not sure, Yukin, but I just want to point out that reckless manslaughter is one of the involuntary manslaughter. Okay? You will have to check with your teacher. All right? But for, I think for other degrees like University of London, they have reckless manslaughter. But MMU, I do not know. I have to be honest. So please check with your criminal lecturer whether that would be covered or not. If you do not have to cover it, one less things to cover, okay? But remember, you will have to get into the mentality that it is going to be a closed book. You will have to start putting down the key cases on your revision notes, on the revision cards, so that you will start to recite those names, okay, from time to time. You don't leave it to the very last moment. It will be very painful if you leave it to the very last moment. Okay, that would be the end of tonight's tutorial. I hope all of you can get something out of it, okay? And at the end of the day, you must put in all the work. And those students who put in all the work, who do a systematic revision, study notes, you are going to get very good marks, and you are going to get the distinction. You're going to get the upper echelon of the 2-1. Okay, I think you have some time before you go to the next tutorial. I'll stop here. All right, and I leave you some time to get a break, a short break, get some water, get some food. I'll see you in the next tutorial. Work hard, and it'll be after Christmas and the New Year. So Merry Christmas and a Happy New Year. I'll see you afterwards. Okay, bye-bye.